The Supreme Court just handed down a 6-3 ruling that's rewriting America's firearm laws. If you own a gun, live in a restrictive state, or care about constitutional rights, this directly affects you. Hit subscribe and turn on notifications. This is one legal battle you cannot afford to miss. What the 6-3 decision actually says: the Supreme Court's 6-3 ruling landed like a constitutional earthquake across American firearms law. 6 justices aligned behind a majority opinion that doesn't just resolve one dispute, it systematically dismantles the legal architecture that anti-gun states have built for decades. What separates this ruling from prior Second Amendment decisions is the precision of the majority's language, deliberately written to eliminate gray areas that lower courts exploited since Heller 2008 and Bruen 2022. According to federal court records, lower courts issued over 200 Second Amendment decisions between 2022 and 2024, with many finding creative ways to uphold restrictions despite Bruen's historical framework. This ruling was written specifically to shut that down. The 6-3 margin itself sends a structural signal. Unlike a fragile 5-4 decision, a 6-justice majority arrives fully intact, with maximum constitutional force and ideological durability to survive future court terms without being narrowed from within. When 6 justices speak this clearly on a constitutional question, every lower court judge is legally obligated to listen, whether they agree or not. Legal historians are already calling this the most consequential firearms ruling since Heller itself. Key legal arguments behind the majority opinion. The 6 justices who formed this majority built a legally airtight argument that future courts will find difficult to work around. Understanding that argument is key to understanding why this ruling hits harder than anything before it. The majority's first move was rejecting the government's reliance on interest balancing entirely, slamming the door on the idea that states can justify restrictions simply by claiming they make people safer. Under the Constitution, good intentions don't override fundamental rights. Their second argument leaned on a critical historical fact. At the time the Second Amendment was ratified in 1791, there was virtually no American legal tradition of banning entire categories of commonly owned firearms from law-abiding citizens. The majority held that this historical silence speaks louder than any modern policy argument. A Georgetown law study found that of over 1,300 firearms regulations examined from the founding era through the 19th century, fewer than 3% involved outright categorical bans on weapons in widespread civilian use. This majority used that data as a constitutional hammer. The message to anti-gun legislators is simple: if you cannot find your restriction in 1791 American history, your law does not survive. No amount of modern political pressure changes that. Most significantly, the majority reaffirmed the common use doctrine head-on. Any firearm owned by millions of law-abiding Americans for lawful purposes sits at the absolute core of Second Amendment protection and cannot be categorically banned, regardless of how dangerous a state claims it to be. Why the dissenting justices strongly disagreed. The 3 dissenting justices argued the majority's approach is dangerously disconnected from the real world Americans actually live in. Their dissent was sharp, emotional, and backed by sobering numbers. According to the CDC, firearms are the leading cause of death for children and teenagers in the United States, surpassing car accidents since 2020. From their perspective, a constitutional framework that makes it harder for elected governments to respond to that crisis enables tragedy, not freedom. Their core argument, the majority's rigid reliance on 1791 history, is fundamentally flawed because the founding era had no AR-15s, no 30-round magazines, and no weapons capable of killing dozens in seconds. You cannot look to 18th century history to regulate 21st century firepower. The dissent warned this ruling will trigger a flood of litigation clogging federal courts for years, while dangerous weapons remain on streets. All 3 dissenters signed one unified opinion, a rare show of opposition, signaling how deeply these 2 legal visions conflict. They raised an institutional warning: a Supreme Court striking down democratically enacted safety laws based on 18th century analogs prioritizes ideological consistency over the lived safety realities of 330 million Americans alive in 2025, not 1791. How this ruling impacts federal firearm regulations. This ruling doesn't just shake up state laws, it sends shockwaves into federal firearm regulations millions of Americans interact with daily. The federal government enforces over 20,000 firearm-related laws across agencies, including the ATF, FBI, and DOJ. A significant portion were built on the legal foundation this 6-3 6-3 majority just cracked. The ATF alone issued 100+ regulatory actions since 2021, covering pistol braces, solvent traps, and ghost guns. Virtually all are now legally vulnerable because they were justified using the interest balancing approach this ruling buried. A 2024 Cato Institute analysis found approximately 47% of currently active federal firearms regulations lack clear historical analogs from the founding era, meaning they cannot survive the standard this majority enforced. For average gun owners, federal agencies like the ATF now face their most legally exposed period ever. The ATF's annual budget for firearms enforcement exceeds $1.7 billion, much of it now defending regulations this ruling rendered constitutionally indefensible. What it means for state-level gun restrictions. If you live in a state with strict gun laws, this ruling changed the legal ground beneath every restriction. State legislatures are scrambling to defend regulations more seriously than headlines capture. According to the Giffords Law Center, over 300 active state-level gun restrictions across 27 states directly conflict with the historical framework this majority reinforced. More than half the country sits on firearm laws now constitutionally exposed to challenge. States like California, New York, Illinois, Maryland, and Massachusetts built entire regulatory layers on the interest balancing approach this ruling discarded. Those layers are now legally unstable. A 2023 National Shooting Sports Foundation report found the most restrictive states average 47 separate firearm regulations per state. Each must now survive the demanding historical analog test. For gun owners in those states, this transforms constitutional rights from theoretical promises into enforceable guarantees that state governments can no longer casually override. A Firearms Policy Coalition survey found 68% of gun owners in highly restrictive states are now aware of this ruling and contacting legal advocacy organizations. California, New York, and Illinois have already begun allocating emergency legal defense funds to protect their most vulnerable restrictions. The Department of Justice's next legal move. The DOJ isn't sitting quietly. It's actively recalibrating its entire firearms enforcement strategy. The moves it makes in coming months will determine whether this ruling transforms American gun law and practice or gets suffocated by bureaucratic resistance. The DOJ oversees a firearms enforcement budget exceeding $120 million in 2024, funding prosecutors, ATF agents, and legal teams whose infrastructure was built around the regulatory framework this ruling challenged. According to federal court records, the DOJ was actively defending 80+ firearms-related cases as of early 2025. Everyone must now be reassessed, restructured, or potentially abandoned under the new constitutional standard. Following the 2022 Bruin ruling, and the DOJ took an average of 14 months before meaningfully adjusting its litigation posture. Gun owners should expect prolonged legal turbulence before federal enforcement aligns with what the Supreme Court decided. The critical question, will the DOJ respect this ruling genuinely or find creative workarounds? History suggests the answer won't be straightforward. Since the 2008 Heller decision, the DOJ has spent an estimated $340 million defending firearms regulations, much of it defending the exact interest-balancing justifications this majority permanently rejected. The current administration's public stance on firearms restrictions now conflicts with what 6 Supreme Court justices declared to be the law of the land, creating institutional tension between executive policy and judicial authority with no easy resolution. How this decision connects to previous landmark gun cases. This 6-3 ruling didn't arrive in a vacuum. It's the latest chapter in a constitutional story building for over a century. The Supreme Court's modern Second Amendment journey began with District of Columbia versus Heller, 2008, where a 5-4 majority established that the Second Amendment protects an individual right separate from militia service. Harvard law scholars called it one of the most debated constitutional decisions of the 20th and 21st centuries combined. Then came McDonald versus City of Chicago, 2010, extending that protection against state and local governments. McDonald triggered 400+ new Second Amendment challenges within 18 months. Bruin arrived in 2022, replacing the balancing test impressed with the historical tradition framework. Now, this 6-3 ruling has sharpened that framework into the most precise constitutional tool Second Amendment advocates have ever had, creating an unbroken legal line from 1791 to today's courtrooms. What you're witnessing isn't just one decision. It's the culmination of nearly 2 decades of carefully built precedent, reaching the clarity and force advocates have fought for since the first post-Heller challenge in 2008. Between 1939 and 2008, nearly 70 years, the Supreme Court issued 0 major Second Amendment decisions protecting individual gun rights. The entire modern framework was built in under 17 years, now culminating in this ruling that may define American firearms law for the next half-century. That 70-year silence, followed by this rapid succession of pro-Second Amendment rulings, signals a fundamental philosophical transformation on the court. This 6-3 decision is its clearest, most forceful expression, what gun owners and lawmakers should expect next. The moment this ruling was handed down, a countdown started in courthouses, state legislatures, and federal agencies nationwide. According to a 2024 Duke Center for Firearms Law report, 150-plus active Second Amendment cases are working through federal circuit courts, and everyone just got a significantly more powerful legal argument injected into it. For gun owners, certain challenged restrictions may begin falling faster than ever before. Some experts estimate up to 70 federal court decisions upholding various restrictions could be reversed within 24 months. For lawmakers in restrictive states, the expectation is equally dramatic. In the opposite direction, legislative offices in California, New York, and New Jersey are auditing every statute against the new standard, knowing defending exposed gun laws now costs states an average $2.3 million per major case. The bottom line, the legal and political landscape around firearms has fundamentally shifted. Anyone not preparing for those consequences is already behind. Second Amendment organizations, the Firearms Policy Coalition, Second Amendment Foundation, and NRA, are treating this as a generational opportunity, accelerating litigation to file challenges while this ruling is fresh and maximally applicable. According to internal strategy documents, these organizations have budgeted over $45 million specifically for post-ruling litigation in 2025 alone, virtually guaranteeing this decision will be tested, expanded, and applied in courtrooms nationwide before the current Supreme Court term ends. This 6-3 ruling has lit a constitutional fuse burning through every level of American firearm law simultaneously. The explosions are just getting started. Drop your thoughts in the comments below. Share this video with every gun owner you know. Hit that like button and subscribe so you never miss a critical update.